All right, greetings everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Um, Gonna do a thing on receivership tonight, and before I do get started, I do want to thank everybody for your continued support. However, I do sadly have to report that somebody else thought that they needed my bike more importantly than I did again, so it was once again stolen this year. So anybody that can help out with some love in the PayPal link, it most certainly is appreciated. In the meantime, let's get started with our presentation on receivership. See where we're at here. And receivership. What is it? And how it works versus bankruptcy. Receivership, what is it? How it works versus bankruptcy. So if there's no bankruptcy really going on, then it should be set up as a receivership. Okay. First and foremost, a simple statement like that is what it's telling you. It's either a receivership or it's bankruptcy. That's why it's telling us versus. There's some kind of difference. They're opposing. A receivership is a court-appointed tool that can assist creditors in recovering funds in default and can help troubled companies avoid bankruptcy. Having a receivership in place makes it easier for a lender to obtain the funds that are owed to them if a borrower defaults on a loan. A receivership may also occur as a step in a company's restructuring process that is initiated to return a company to profitability. And if you remember what we spoke in our last one on bifurcation and hypothecation, the two videos that we did there, we were talking about this. Bifurcation is a splitting and thereby resulting in a restructuring of two different entities. And it's done for greater profitability in hypothecation. Moreover, a receivership could arise as a result of a shareholder dispute over completing a project, liquidating assets, or selling a business. Now, the shareholder dispute is in relation to that state entity where there are many shareholders in it. That resident United States citizenship over completing a project. And what happens is one of them officers will come along, or agents, and project that you're part of their association and you need to complete some paperwork because they have a dispute as a shareholder in the statutes, codes, rules, and regulations of that citizenship. Key takeaways. A receivership is a court-appointed tool that can help creditors to recover funds they're owed. And why would that be a takeaway? You suppose maybe the takeaway is because they don't want you to realize that the true creditor is you, and it's a takeaway for them. So, as we continue on, it says it can help troubled companies to avoid bankruptcy. Troubled companies to avoid bankruptcy. Companies that would have assets proving that they are soluble. They have liquidable assets. The goal of a receivership is to return companies to profitability. In a receivership, the court appoints an independent receiver or trustee to manage all aspects of a troubled company's business. I remember what we talked about in the bench warrant. They issued it and they did diligent duty to serve, and they gave it to the servicer, the United States Postal Service, the registered agent or trustee in receivership, because they're the ones that received it, and they expected to be able to pass it on to me but couldn't find me, so I wasn't in receivership, and this is what I told them: I never received it. Oh, well, we'll dismiss the bench warrant then. See, no trustee stepped up and took it. So again, like I said, a trust shall not fail for want of trustee. So they already issued the bench warrant for $350, forming a trust, but the trust shall not fail for want of trustee. So since I didn't show up as trustee, they did, or when I did show up, I told them I never received it. So instead of actually dismissing the bench warrant, they accepted my appearance in court as if though they gained personal jurisdiction, even though they still never got a receivership on the summons, nor did they send a waiver of personal jurisdiction to qualify that. So instead, they posted a continuance as if the presumption still rode, even though I rebutted it. For the duration of a receivership, the company's principles remain in place. For the duration of a receivership, the company's principles remain in place. Now, the principle is different than the obligor. And like I showed you in the court documents, they placate that the name that I gave them, the legal name, the first name and last name, is up for conversion. So they use the first name with the firm name, which is just the first four letters of the last name in all uppercase. I have never once been taught to write my name in all uppercase, first and last, first, middle, and last, whatever, nor have I ever been taught that there is a use of a firm name, which is just the first four letters of the last name. So, as we continue on, it says the state of an enterprise being placed under the control of a trustee, usually when it can't meet financial obligations. That's a receivership. That's Investopedia, receivership, the state of an enterprise. And remember, admiralty deals with prizes, claims of prize. And somebody enters a prize, a document known as an asset that somebody can claim as a prize, or the collateral thereto. How receiverships work. In general, a receivership is a process that is put in place to protect a company. Okay? Remember, that legal name is the foundation of a legal corporation. A period of receivership may be thought of as a protective umbrella for a troubled company, or one that's being that is incompetent. During this time, a receiver or trustee steps in to manage the entire company, its assets, and all financial and operating decisions. So when you filled out the SS5, what you did was you assigned a trustee, the state's Social Security Administration, to step in and take care of all financial and operating decisions through their administration. And that is the probated estate, because you did not only submit a living will, but you proved that of age of majority that you were not competent to do so. And the proof is that you handed it all over to them. While the receivership is operative, the company's principals remain in place as material contributors, but their authority is limited. See, that Social Security tax and the FICA, you're contributing. All of that stuff that you pay through those labor organizations as an employee, that Social Security is considered taken out because you're qualified as a Medicare qualified government employee. okay, in a public contract for compensation known as public employment. If you were under private employment, you would have a common law contract, and you would fill out a W-4 and let them know that you're not making an agreement with the employer according to their statutory code, but rather to the common law privately, so you can be compensated for your labor, which cannot be converted to a commodity. Okay. Traditionally, a receivership was intended to help creditors recover amounts outstanding under a secured loan in the event that a borrower defaulted on its loan payments. Receiverships are one of the most powerful solutions available to aid creditors. So when we do a receivership, by making the assignment so that they receive what is intended to be received, which is an execution of a living will to remove that probated estate into equity, so that all administrative matters over the estate so probated can be settled and cleared. Receiverships are also used by companies that are in financial distress. This is the financial distress that you're in under fines, fees, and penalties, and yet the receivership is using the principal as an investor and laying out the liabilities on that very principal through the indoctrination of public education that teaches us to write the legal name and not concise English, where we're taught that the given name is supposed to be separated by a full colon hyphen or a full colon stop, as well as the last or a family name. They can be used as part of a company's restructuring process. So what they're doing in these courts, these administrative courts that are not quite operating in bankruptcy, they're operating in receivership. And then they're bifurcating and hypothecating through an abrogation. This is why they use a subrogation technique to fix things, because they claim that you're the debtor when in fact you're the creditor. Again, on form A0430, it tells us the plaintiff is a debtor, and it tells us the defendant is the creditor. For example, a receivership can help when a company makes significant changes to its financial or operational structure, typically while under financial duress. You get a ticket, a citation. That's a financial duress for somebody that's incompetent and cannot manage their financial affairs. So a receivership can help when a company makes significant changes to its financial or operational structure by handing it over to somebody else. So that receivership is supposed to help you, but instead, through that bifurcation, hypothecation, abrogation, they are in fact using those security instruments and your signature as cause for liability. That signature, known as an endorsement, that we'll talk about later at 10 o'clock. I'm going to come back and we're going to do another video on endorsements, and we're going to show you that an endorsement is an amendment to an insurance policy. Every time you sign your signature to an application or some kind of government or commercial form, taxes, banking, when you fill out the account statement and everything to open up an account and give that information, yeah, you're handing it over to somebody else to take care of your financial affairs under their operational structure. And that operational structure, in case you're wondering, again, is 32 USC 151, 31 CFR 151.2, I believe it is. I'll have to check. Maybe it's 151.6 or something. But it's up in there somewhere. It's area office. And it says that the selective service is responsible for all administration and operations of the board or boards within its local jurisdiction. And if you remember, you have to have a corporate structure that's got a board of directors in order to hire an attorney to enter into these courts. That's why there's an assignment of a receivership for a trustee, because you're not allowed and you're not granted the authority to do so. Your authority is limited. It is limited to private directives because you are not a public official. Private directives come by way of equity. So, typically while under financial duress, or a receivership can be used when a company is headed towards bankruptcy. So again, if you're headed towards bankruptcy, it's only because they deem that you have no assets and the only thing they can count on is your signature. A receivership itself is not a legal process, but it is usually invoked during legal processes or proceedings. Either the secured creditor, the lender, or a court of law appoints a receiver to act as trustee of a business. Privately appointed receivers will generally act on behalf of the secured creditor that appointed them. Privately appointed receivers will generally act only on behalf of the secured creditor that appointed them. That is obverse from a court-appointed attorney that is going to represent you and not act on your behalf. See, an attorney doesn't act on your behalf, he represents you. But a receiver privately appointed acts only on behalf of the secured creditor. The document will show you the secured creditor again is you. Form AO 430 under the administrative offices of the United States Supreme Court clearly states and recognizes that the plaintiff in those cases, administrative cases, anybody that brings an administrative claim has to be part of the administration. Even if you have a bike stolen, you can call them up and they will make up a case number for their administrative purposes in their administrative courts if that bike is ever found and I want to prosecute through those administrative courts. Excuse me. However, that is not the process I can do. What I can do in regards to the correction of the records is invoke it during the legal proceedings of the record keeping. That's what we're attempting to do now. The receiver must be an independent party with no prior business relationship to either the borrower or the lender. With no prior business relationship to either the borrower or the lender. So that excludes the state because the state uses minimum state contacts. In other words, prior business relationships to establish that they are the plaintiff making a valid claim against a defendant. That's what their claim is. It's based on prior business relationships. So again, a receivership itself is not a legal process. It has nothing to do with the prior business relationship as a legal process, but rather it is usually invoked during legal proceedings by a court of law to privately appoint receivers to act on behalf of the secured creditor involved in the business relationship. The creditor is the one that's actually signing all the documents. Responsibilities of a receiver. In the case of a restructuring, and this is actually what we're doing because we're going to correct the record and it's going to require a restructuring because we are in fact not structured and organized accordingly under the laws of the United States to do such things. The appointed receiver generally has ultimate decision-making power over the company's assets and management decisions. This includes the authority to stop paying dividends or applicable interest payments. This is the important part in a qui tam amicus curiae in the name of the United States as a friend of the United States to prevent any more use or abuse of the interest that belongs to them by the state. The state is using the interest of the United States to their advantage by not including them in these administrative plaintiff claims. When again, that administrative court is under this administrative offices of the Supreme Court of the United States. The receiver also ensures, kind of like insures, huh? So the receiver also ensures, does that sound like a suretyship? It creates a suretyship, folks. That all company operations comply with government standard regulations while still maximizing profits. In other words, it's saying that if you're not a company, you don't have to comply with government standards and regulations, and they've been taking everything and using it against you for their benefit, maximizing their profits. This is the importance of reviewing the record. The record will clearly show you are not a federal or state or municipal officer or agent whose resident presence is deemed necessary by the board. Assigned so in receivership. The receiver customarily works with the company to help avoid bankruptcy, not only as a matter of structuring it as a avoidance of bankruptcy, but to prove the true asset and who it truly belongs to, and establish that value system as separate and equal to that of the judicial system that it's administrating now. See, that judicial system actually can't hold any property. What it is, it's a military system, and it only holds property in abeyance. In other words, it can only hold it until a proper claimant come forward and make a valid claim. This is a salvage claim. You're going to go back and salvage the abandoned property that's been floating around in the seas of Admiralty and having little bites taken out here and there. It's basically all, it's a salvation. Once you get done, it's going to be a resurrection and merger in a new name. You're going to christen the new vessel. That's what it's all about. It's redemption, returning, prodigal son. If you don't understand the scriptures and how it works in this stuff, then please start all over again. So let's go back. A receiver may choose to shed select assets for the purpose of paying some creditors and to bring the company into a period of recovery. Okay, what is recovery versus discovery? You know, I had an issue when I was 10 years old, and the teacher tried to tell me that Columbus discovered America. And you know, I made a big issue of it and damn near got kicked out of school. I had to go to the principal's office and everything. Got up and told the rest of the class that the teacher was lying, because I knew that Columbus did not discover America as I thought my 10-year-old mind portrayed. After I got older and I started doing the research into this, portraying in my little mind that there were people that were already there, so they actually, if anybody, discovered America first. So when we look at the terms discover and recover, what is the root word? It's cover. So when Columbus discovered America, that's actually a true statement, because America was there and protected by nature. And by him coming in under this doctrine of discovery, he was able to cloud it with fucked up colorable titles. Do you understand now? Now we're going to recover it. And that recovery is going to cover it with its original natural protections again. This is redemption. The land shall not be sold forever, for it is mine, and ye are strangers and sojourners with me. In all of the lands of your possession, ye shall grant a redemption. So, should these, and that redemption is help the land recover from its condemnation. In order for them to use it for commercial purposes, they have to condemn its natural use. And therefore, it was used for commercial purposes and placed a scab, and now it needs to recover. Okay? Should these efforts fail to achieve the purpose of the receivership or be seen as insufficient from the start, the court may order that a company's assets be liquidated. Again, this is a salvation operation, a salvage operation, and restructuring from that which is left, so you can liquidate the assets and rebuild anew. He shall make all things new. In that case, a liquidator would oversee the sale of assets. The assets in this situation, or all the bonds and everything, are floating out there. They need to be called back, even if they haven't matured yet, and sold off. Those are technically your assets. They belong to the principal. And so long as they're out there, they're going to be causing harm. This is the key to Met. You need to help the United States collect on their interest of the obligation. So you pull them in and release them of their obligation through a discharge, full acquittance and discharge. Well, no person shall be held liable in any court. That includes the person known as the United States in their courts of bankruptcy. You clear the debt and collect the funds to repay the creditors. When the assets are all sold, the company would cease to exist. So why? Because it merges into a new company and goes under a new name, never to be recognized again. We see this time and time again. Ma Bell, and now we don't see Ma Bell anymore. Why? Because it was a merger. It was a salvation of what was being operated under Ma Bell. And in order to save everything they could, they liquidated, and the remaining assets went into AT&T. Bankruptcy versus receivership. How are they different? Confusion over the terms bankruptcy and receivership is quite common. The fundamental differences are fairly straightforward. In bankruptcy, it ceases to exist and everything's liquidated to pay off the creditors. Whereas in receivership, you get a new daddy. But if you do it right, you choose your new daddy, yourself. Ye are gods. This is Jacob's ladder, recognizing that the struggle is yourself. So long as you can learn how to bring yourself out of debt, that also leads again to the equal station in life with that of the United States by bringing them out of debt. Don't you get it? That's equity. Bankruptcy is an action that's usually taken to protect a debtor from the collection actions by creditors. If all these people are out there claiming to be creditors and they're not, and you're the true creditor, don't you think it's wise to step up and protect your assets? And don't you think that the United States would be glad to collect on the interest of that obligation and have that obligation released so that debt wouldn't be posed against them again and again and again and again, as a case record of 94 cases would show? How about all the loans and stuff that might have been taken out? Those are debts too. School loans, bank loans for automotive loans, house loans. Those are all securities that are being mishandled, and that's a debt against the United States. All under that probate estate, because you couldn't manage your own financial affairs. Once you learn how to manage your own financial affairs, you resolve them in equity and say, yeah, that's mine. You no longer touch it. So let's get back to it. Bankruptcy courts and rules are primarily aimed at shielding the borrower, not the lender. A company may file Chapter 11 bankruptcy when it wants time to solve its financial problems while maintaining business operations. On the other hand, when a company files for Chapter 7 bankruptcy, it's generally for the purpose of liquidating and closing a business. There are other forms of bankruptcy, but these two are the most common. Let's take a look at something real quick. Make sure we're still going here. And while I'm looking this up, I want to remind everybody, please hit that like, share, and subscribe button. And of course, PayPal links down in the details for anybody who wants to share some love. And now we're going to look at U.S. code real quick as a short offspin of this receivership, because Chapter 11 is the bankruptcy title. And what we're looking at here is one of those other forms of bankruptcy. And this is ancillary. In other words, it's not allonged, it's ancillary to. It's relative, but not necessarily attached. For certain specific reasons, maybe certain deceptive forms that are in error, and therefore, though it may be relative and have certain things structured to look similar, it's not really the same. It's not really like kind. It's something created outside of the United States, and therefore in other cross-border cases. Remember, we spoke about 26 USC 1031. Exchanges of real exchanges for investment, or exchanges of real property for productive use or investment. And that's where subsection H mentions outside of the United States being not of like kind. Purpose and scope of application. Says the purpose of this chapter is to incorporate the model law on cross-border insolvency so as to provide effective mechanisms for dealing with cases of cross-border insolvency with objectives of cooperation between courts of the United States trustees, examiners, debtors, and debtors in possession. See, they're debtors in possession, folks. They got a record. And that record says that you're a United States citizen born in the United States, and yet they have no registration proving that it's substantiated in their records, correlating that you're in fact born in the United States. The courts and other competent authorities of foreign countries. See, the state of Iowa is a corporate entity as an enterprise, a franchise of sorts of the United States. You know, there's an open panel, Harry Nutt, if you want to come up, coming up onto this panel and talking about interesting info, but none of it helps or solves any issues for anyone. It took a couple decades to develop this system. It's going to take a while for some of us to figure out. But I guarantee you that some of us have already figured out. And in case you haven't figured out, it's called private relief law. It comes through courts of equity. That's what we're dealing with. And it's something you have to learn how to pull out your ass and do yourself, because it's not something anybody else can do for you. So just tag along and bump along for the ride in the dust. Got it? Tired of the insane attitude and comments. So let's get back to it. Foreign countries, as it relates to the state of Iowa, like I said, is a franchise or enterprise of the United States, organized under the laws of the United States for statutory and executive order contracting. Contract terms and conditions must be implemented. So the Republic of Iowa is a foreign country. Remember, I told you about the United States is conferring a nationality of a United States citizen upon one that is born in the United States. And again, that's false, because the United States is a corporation and not a nationality. Okay? This info solves nothing. Prove me wrong. Okay. It proves the record is in trust form. Signed instruments under trust law. Where do you think the definitions come from? They tell you. So let's go back to the receivership then. Because now receivership, unlike bankruptcy, again, a receivership is not a legal action. It is not a legal action. It is not taken care of in a court of law. Receivership is a court of equity as an assignment in private chambers in camera. That's what chambers mean. It's a business relationship in chambers, privacy. In camera means no extra third parties. You have a receiver assigned as a third party between you and the court. The court's the one that's keeping the record. It's an administrative record. But rather an adjunct solution. You have to create remedy and equity. They have all kinds of solutions already accorded in their statutes, but those are only equitable and only usable by legal entities. Again, if you are not organized properly under the laws of the United States and have a board of directors in order to hire an attorney, then you cannot make any kind of representment, or any sending into the courts. It has to be done privately. Matthew 18, verse 15. If you have aught with your brother, then you go to him in private. Just because he came to you in public doesn't mean you respond in public. For example, in the case of a secured lender, a receivership is designed to protect the borrower's assets that represent the loan during an interim period until the creditor's claim is resolved by a court. So until a receivership is set, there is nothing to protect the borrower's assets, even insurance policies. Again, we'll talk about an endorsement being an amendment to an insurance policy. That is the very definition of endorsement, which we know as signatures, signed writings on instruments. If it's an instrument in trust, then that signed writing should be as an assignment in receivership. The secured lender asks the court to protect its security, collateral, land, buildings, business income, cash, or the like. These are the negotiable instruments or cash, as we spoke of, that you sign. All those documents you have that have them values and everything, and all them numbers that you sign, that's cash, or the like, the certificates that come from them that are signed by other people that have your name on them. An independent party is put in charge of the assets. Put in charge of the asset and remains in possession and control of them until discharged by the court. Once you are charged, it has to then be discharged. It is not set up It is not. It is not set off. It is not except for value. It is discharged. Now, if you want to be in receivership of a coupon, then you go ahead and keep accepting those coupons through the mail as the receiver and being responsible as a trustee to transfer that coupon as an asset. Because again, we're going to show you what happens when you do that with endorsements. What are some benefits of receivership? There can be benefits for creditors as well as a company. Creditors can ensure that the assets that secure the loans they made to a company remain protected and of value until their claims are handled successfully. Creditors can ensure that the assets that secure the loans they made to a company remain protected and of value until their claims are handled successfully. So when you go to the bank and they take down that legal name as a company, as a secured creditor, they swap the use of it because you don't know this. You give them an asset known as a promissory note. They're supposed to use that promissory note to successfully go to the federal discount window to obtain the credits. However, nobody gives them a special directive for that said deposit. Deposit being the unpaid balance of money or its equivalent that a financial institution is obligated to pay or has already paid in credit. Credit device, anything used to obtain money, property, labor, or services. You use instruments that you sign to do so. You are, in fact, the creditor. A business can get a neutral, objective professional to oversee problems that may concern management, operations, financials, and more. A business can get a neutral, objective professional, the judicial department office, or judicial officer department, excuse me. Judicial officer department is a neutral and independent form within the United States Postal Service. Already there, consisting of, comprising of, as they put it, the judicial officer, the administrative law judge, and the Postal Service Board of Contract Appeals. Again, the contract is the legality. Okay? We're going outside of it, but is usually invoked during the legal proceedings. It is not the legal process. It is exterior to the legal process that is already ongoing by the presumption of contracting. That's the legal fiction, presumption. A business can get that, the receiver can help position the company to thrive once the term of receivership ends. A secured creditor can request a receivership as a way to obtain funds or protect a borrower's assets until a court resolves the creditor's claim against the borrower. Perhaps anywhere from a few months to several years. How long does a receivership last? However long it takes to help that organization get back on the feet again like they're supposed to. Or that private foundation, as in my case. It depends on the reason it's implemented in the first place. The reason here would be equity. Equity. Yeah, exactly. Let the U.S. Postal Service trustee come to Keith's aid in court. Sorry, it's not going to happen. It happens in private. And that is the court. Okay? It's the negotiations. Of course they will. That's their international duty under their very own preamble to the Constitution of the Universal Postal Union. Read it. Communicate with the people around the world. That's their ultimate objective. The very first thing in the preamble, buddy. Fair question after his claim of having a trust with them. Yes. And again, the Judicial Officer Department is an independent and neutral forum within the United States Postal Service. So if it's an independent and neutral forum within the United States Postal Service, that would say that the judicial office is also in the United States Postal Service. Unless you don't catch that. Maybe read up on the obligations. So, a receivership put into place to help resolve the claim of one creditor could last less time than one used to remedy a company's ills so that the company can avoid bankruptcy. And there you go. See how these terms are used? A receivership put in place to help resolve the claim of one creditor could last less time than one used to remedy a company's ills so that the company can avoid bankruptcy. Equity abhors a forfeiture. Equity will not allow an injury to be without a remedy. Equity does not allow, let's see, what is it? Let me find them again. Oops. We're going to run down through these. One who seeks equity must do equity. That's why you have to come forth with your own remedy, because they're not. It's not within their law. You have to create it. Equity will not suffer wrong to be without a remedy. Equity regards as done what ought be done. It is a fiction of equity designed to effectuate the obvious intention of the parties and to promote justice. Equity is a sort of equality, like I mentioned earlier, in equal station. Equity aids the vigilant, not those who slumber on their rights. This is the basis for equitable defenses of laches. The equitable defenses of laches is to invoke the remedy through receivership by appointing or assigning a trustee, because a trust shall not fail for want of trustee. Equity imputes an intent to fulfill an obligation. They already had the obligation. How do we know? They're the ones that created this stuff. Equity acts in personam. It's according to the record. Equity abhors a forfeiture. Equity does not require an idle gesture. You have to work at it. He who comes into equity must come with clean hands. This means we come to clear up the record, not to start accusing people. He who comes into equity delights to do justice and not by halves. It's going to clean it all up and everybody's going to walk away clean and whole. Equity will take jurisdiction to avoid a multiplicity of suits. That's the multiple creditors. The remedy. Equity follows the law. Equity will not assist a volunteer. Again, that's the federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board, and everybody's claiming they're a resident. That's a voluntary claim. You were never deemed necessary. Equity will not complete an imperfect gift. Because you were conferred a nationality of a United States citizen, and it's not perfect and cannot be perfected, it is imperfect and will not be complete. It says equity will not make a trust where none has been clearly declared. A defective or imperfect gift will not be converted into a trust. They are only using you as if though you're performing the functions of public office as a public servant for your personal services by signing their official documents, the performance of the functions of public office. Where equities are equal, the law will prevail. Between equal equities, the first in order of time shall prevail. Equity will not allow a statute to be used as a cloak for fraud. Therefore, you invoke a receivership to assign the trustee to create the remedy in a court of equity. Equity will not allow a trust to fail for want of a trustee. Equity regards the beneficiary as the true owner. So if you're the true owner, then you are the true creditor. So again, it's a trust situation, and the trust is already declared, and all you have to do is clarify it by making your declaration in assignment. Continue on, and then we're done, and we'll be back at 10 o'clock. The bottom line, receivership is a court-appointed remedy. It is not a court of a legal matter. It's a court-appointed remedy that may be used to assist creditors. And again, Form AO 430 says the defendant in one of their administrative courts is a creditor in recovering funds due them when a company is unable to make payments on a loan. Why? Because we are not the one that borrowed. They are. And they abrogated it through bifurcation and hypothecation, like I said, using your signature as if though you were the one borrowing, when in fact that signature says you are the creditor. It can keep a company out of bankruptcy as it restructures due to financial hardship. And again, remember, folks, that financial hardship is the placement of you in that government record as if though you're a Medicare qualified government employee signing documents that are amending insurance policies. So, no, it's not. It's a contract with the federal corporation. It's not a contract unless you have knowing, willing intent. It's an implied contract that can be rebutted because until now, it's been nothing but a pure legal fiction. Ask any court. There's no final judgment clarifying it as something different. So, in the meantime, folks, remember, I love you. God bless. I don't give a rat's ass whether you love me back. So have a good time with what you're doing, and we'll see you back here in a few minutes, 10 o'clock, to talk about endorsement, amending those insurance policies we're talking about. Bye now.